We now welcome representatives from Peak Care. Good morning. Could you please state your name and the capacity in which you are appearing today?
Good morning. My name is Tom Alsop. I'm the Chief Executive Officer of Peak Care Queensland, Queensland's peak body for child and family services, and I'm joined by Taylor Collier from Peak Care.
Thank you. Thank you. If you'd like to make an opening statement.
Thank you very much. I would like to start by acknowledging traditional owners on whose lands we are meeting today, pay my respect to elders past, present and emerging. And I would also like to thank the committee for the opportunity to appear today with my colleague Taylor to speak on the bill to introduce Daniel's Law. Peak Care is the peak body for Queensland's child and family sector, and at the heart of what we do is protecting the lifelong well-being and safety of children and young people. We represent the child and family services sector, thousands of organisations across Queensland who at the heart of their work is the safety, well-being and upholding the rights of children, young people and their families. I would like to acknowledge at the outset the tireless dedication and advocacy of Bruce and Denise Morgan. Queensland's children, my children, our children are safer for their work, and Australia's children will continue to be safer for their tireless advocacy. We support this bill, and while we support this bill, it's important to acknowledge that keeping children safe is everyone's business, and as a community, safety is paramount. But public registers alone will not create safety. We know from experiences in the United States, which have been talked about already, and more locally in Western Australia, that without investing in those additional educational supports, the continuous evaluation and the broader range of safeguards that are required to keep children safe, these kinds of schemes can fall short of living up to their full potential and they can create unintended harms. Peak Care urges the committee to consider action-based research and continuous evaluation alongside the implementation of Daniel's Law. From the outset of its implementation. The bill does not provide for evaluation until the 5-year point after its commencement, and we know from the international evidence that if you can walk alongside a bill of this importance and continue to learn and evolve over time, you're going to set that bill up for its greatest success, rather than having to address unintended consequences well after they've become entrenched. We acknowledge and welcome the bill's provisions that exclude children and young people who have offended where their offences have only been occurred as a child from public identification, and uphold the court's non-publication orders. This approach will reduce the risk of disproportionate harm and support rehabilitation. We also support the bill's creation of a new offence to prevent harassment and intimidation, which will help prevent vigilantism. We do note the bill is silent on prevention and community education. If we are serious about protecting children, we must equip families with the educational supports that they need to recognise the risks and take both proactive and protective action to support their families. This should be done in collaboration with peak bodies and culturally and linguistically diverse communities. Finally, we do hold, of course, concerns about the override of the Human Rights Act. However, we acknowledge that there should be an intense focus on the temporary, justified and close monitoring of any potential harms that may result, and that strong safeguards and reporting obligations, as well as the consideration of an earlier sunsetting period, should be considered to ensure that there is an effective balance. In conclusion, Peak Care supports the shared goal of strengthening community safety. We welcome the bill's provisions that reduce reintegration harms. They protect victims as well as protecting them from offenders from vigilantism. But we also need to ensure continuous evaluation, prevention, accessible and transparent means of accessing information are available to ensure that Daniel's Law can live up to its promise. In closing, it's really important to acknowledge that in Australia today, the Australian Child Maltreatment Study says that 1 in 4 children before the age of 18 will be sexually abused. That is the current experience of Australia's children. This is an urgent national problem. It's widespread in our communities, it's enduring and it's entirely intolerable. Daniel's Law is an important step in protecting Australia's children, but it is not the last step we should take. Thank you. I welcome your questions.
Thank you. In your submission,